the state of distress, that is to say, what is considered a slight state of neglect, provides an optional report, so it is left to the sensitivity of the operator to assess if it's the case or not of reporting. The real state of neglect is a different condition, and Law 149 of 2001 provides an obligation to report, and it can be under the civil code to the juvenile court. If the child is a victim of a crime, our regulation provides two different forms of reporting. One is a criminal complaint and the other is medical report for health professionals. As for the obligation for complaint and report, professionals that are public officials or in charge of public services, and during their activity they are made aware of some dangerous situation, then they are obliged to report. This is a prosecutable offense, and so there is a protection, so the opening of judicial proceedings regardless the willingness of the victim to report or not. So reporting is kind of a picture of fact. So you have to depict in the clearest way possible what happened or what you have been told. So it could be direct narrative. So, for example, the child telling us his story. We can even quote the child's words or tell what the parents told us. So focus on the parents' narrative. So it means that we do not learn something directly, but we have been told this by somebody else. So anyway, we can be called as witnesses about what we have been told. Different is if we identify directly any physical sign or bruise that can be indicators of abuse or neglect. These are the most complex cases that can be bruises, and of course physicians know how to identify child abuse, and it is necessary to immediately report it to judicial authorities. And then so reporting to other bodies such as schools or institutions or associations, they can be focusing on overt injury or presumed assumption. So you shouldn't have any problem if you have doubts if the child is victim or not of abuse. You do not have to be certain. I mean, if you have strong doubts about it, it is necessary and it is compulsory to report such doubts. As for the criminal complaint, it must be filed in writing. Of course, phone calls can be made, but to file a complaint, you have to file it in writing. It shall not be anonymous, and it must include some elements that are essential to depict the situation, and including clear and precise elements about, for example, the people involved. It is fundamental that the report must be made promptly. The law sets forth that in case of medical report, it must be provided within 48 hours, and in case of danger in delay, you have to file it immediately to the prosecutor or to the police. While the criminal complaint shall not be filed within a specific day, but it shall be filed without any delay, because when you file a complaint, of course, you have to acquire all the elements in order to support your doubt. But we shall not forget the fact that you do not have to disperse any evidence, so timeliness is essential. So you should involve police, or for example by calling 112, 113, in case you want to be timely and react promptly, so that a policeman or policewoman can immediately identify people involved, or can identify promptly the condition, the situation, or what the health professional, the teacher, or the social worker is dealing with.